earlier the better. I had the day off.
Who else is hearing petition challenges on that?
It would be,
Council, Friday in the afternoon works for them.
well, yeah, in the morning,
I
different cases.
understand that if you're going to file a motion, you
Two other
may
objection
need
hearings.
a longer time.
9:30.
If necessary, I'll file it today. And then if the rules today may be Friday, we need to take it Friday, and then it's going to be next month, Tuesday, Wednesday.
What is everyone's Monday or Wednesday?
Monday's fine.
My Tuesday's booked up.
I'm available.
Yep.
I have nothing coming up, so I don't know. I think it's not doing what I wanted to do.
So Monday or Wednesday, Friday, Monday or Wednesday is what we're looking at.
Is what we'll be looking at.
Okay.
Monday, I'm going to have some thirty, once we change the time.
Monday morning.
Monday morning.
I might be available at
I'm sorry?
11, I'd be available. I was going to get this done.
I'd rather just do it on a day we're free. Does Wednesday work for everyone?
We're getting a little far afield. I'm just saying, because I can tell you what's going to happen. So we get this done, and then the petition for judicial review is filed, and then the chairperson is in the courtroom saying, hey, I got to print ballots, because we didn't allow enough time. This schedule needs to be truncated so that it allows, and I'm not writing a brief 12 hours after I file, which is the first, I want to get this done so we can get to the next step. Because we want the court to be able to print ballots and not be pressured.
Why don't we see where we find ourselves at the conclusion of the matters that are up for review today? Then we can revisit what we think the appropriate briefing schedule is. I think maybe we're getting our report card a little before course. So, Madam Clerk, it's 1:30.
The County Officers Electoral Board is hereby reconvened from June 12, 2020 pursuant to notice and in accordance with the Illinois Election Code as provided for under Illinois law to hear and pass on objections to nomination papers. My name is Clerk Lauren Staley-Ferry and Chair of the Will County Officers Electoral Board. Also present are members of the Electoral Board, Mr. Timothy Brophy, the Will County Treasurer, and along with the public member appointed by the Acting Chief Judge of the 12th Judicial Circuit Court, Karen Stuckel. Also present is DuPage County Assistant State's Attorney Connor McCarthy, the special counsel appointed to advise the Electoral Board. The first order of business today will be to adopt the Electoral Board rules of procedure that will govern all of the Electoral Board proceedings.
I move we waive the formal reading of the rules.
Second?
A motion has been made and seconded to waive the formal reading of the rules. Is there any discussion on the motion? All in favor of waiving the formal reading of the rules, say A. Opposed, say nay.
Aye.
Aye. The motion carries.
I move for adoption of the rules.
Second.
Is there any discussion on the motion? All in favor of waiving the formal reading of the rules, say aye. Any opposed, say nay.
Aye.
Aye. The motion carries. Do we need to go ahead and sign the
Yeah, if
rules,
you could
Counsel?
sign the rules now, that would probably be easiest.
And then, again, before we go ahead and get started, please remember there will be time for comment at the end of the meeting. There will be public comment at the end, so please remember that and just make sure your comments are made at the end. Legal counsel, will you please commence the proceedings on behalf of the board?
The matter before the board is case number 2020-1 entitled Gerard v. Munoz. Richard Gerard, objector, and Richard Munoz, candidate for the office of Will County State's Attorney, to be voted upon at the November 3rd, 2020 primary election. The records that the board will consider and which will be made part of the record for this hearing are the verified objector's petition, which will be marked as Exhibit A, the call notice for the Electoral Board hearing on June 9th, 2020, which will be marked as Exhibit B, The correspondence from the clerk of the circuit court indicating a conflict of interest to be marked as Exhibit C. The correspondence from the sheriff of Will County indicating a conflict of interest to be marked as Exhibit D. The administrative order of the court appointing Karen Stuckel as a public member of the Electoral Board will be marked as Exhibit E. The waiver of service for the members of the Electoral Board, waiving service by the sheriff and service by registered or certified mail for the Electoral Board members will be marked as Exhibit F. The registered mail receipt of the call notice to the objector will be marked as Exhibit G. The registered mail receipt for the call notice to the candidate will be marked as Exhibit H. The affidavit of personal service on the call notice for the candidate will be marked as Exhibit I. The affidavit of personal service of the call notice on the objector will be marked as Exhibit J. The candidate's motion to disqualify the county clerk as a member of the Will County Officers Electoral Board will be marked as Exhibit K. The objector's response to the candidate's motion to disqualify the county clerk as a member of the Will County Officers Electoral Board will be marked as Exhibit L. The rules of procedure adopted by the Electoral Board will be marked as Exhibit M. The call notice of the June 12th, 2020 Electoral Board meeting will be marked as Exhibit N. The appearance of counsel for objector will be marked as Exhibit O. The appearance of counsel for candidate will be marked as Exhibit P. Objector has filed his objection and supporting documentation. Candidate has filed a motion to disqualify Clerk Staley Ferry from sitting on the Electoral Board. The board has heard some argument at its last meeting and has reviewed the pleadings. The parties can now argue their respective legal positions on all the issues raised in that motion to disqualify. The candidate will present any arguments he wishes in support of the contention that the Will County Clerk, Lauren Staley Ferry, has developed a pre-existing bias with regards to the objector or candidate. The objector will have an opportunity thereafter to present any arguments in opposition to the motion to disqualify. The candidate will then have a chance to reply to those arguments. Mr. Ivey.
Thank you, counsel, members of the board. Again, we're here today on our motion to disqualify the clerk for interest or bias that may prejudice the outcome. I think it's important to realize that the primary purpose of all election laws is to ensure a fair and honest election. I think it's also important to realize that the policy of the state is to provide candidates for public office with access to ballots and to allow citizens to vote. Ballot access is a substantial right, not lightly to be messed with. That's what this is about. This is about trying to have an open candidate that was filled to be kicked off so that the people of Will County have no choice. While a lot of it is a legal issue, due process demands that the Republican Will County Republican Committee and also their candidate Rick Munoz is entitled to a fair and impartial fact finder, this board. The case cited in my motion, Gerard, states, our system of laws have always endeavored to prevent even the probability of unfairness. To this end, no man can be judge of his or her own case, and no man is permitted to try cases where he has an interest in the outcome. In this particular case, prior to my client even filing his nominating petition, the clerk of Will County developed an interest. The clerk of Will County began investigating this. The clerk of Will County took the unusual step of meeting with the chief judge in a proceeding that initially was sealed, had to be later unsealed, seeking opinions of how to keep Rick Munoz off the ballot, prior to him even filing his petition. I say unusual because out of the part of your normal jobs is to accept nominating petitions. Approximately 318 you've accepted. I would suspect that if we were to call you as a witness, this would be the only one that you did those actions for. It is interesting that your reasoning for this was you were concerned about the fact that Mr. Munoz had voted in a primary for the Democratic Party. This is the same objection that 3 days later Mr. Gerard has filed. Don't know if there was coordination between you and Mr. Gerard, but I do know that you developed an interest. an interest that when Mr. Munoz filed his nominating petition, you were personally there, which you have every right to do. You took 20 minutes, according to the unrebutted affidavit of Mr. Rinkowski, to go through every single bit of his petition to see whether you would accept it. Mr. Rinkowski has practiced election law for over 42 years, and his affidavit, which is unrebutted, he says that his observation of what happened that afternoon were extreme and unprecedented interest by the clerk, that you were individually there, that it took over 20 minutes, that in the 42 years he's never seen something like that. On average, it takes about 2 minutes. I guess the question is, what level of bias are we going to tolerate? Is permissible. When it's the fact finder, we have to be awfully careful. I noticed that in this particular case alone, we have the chief judge recused himself, not because he was personally biased, but the mere suggestion, because his daughter works for Mr. Pyle's law firm, didn't want any hint. He didn't want to taint the proceedings. It is that important. The fact that we could potentially disenfranchise an entire county, it is that important that we need this proceeding to be without taint. Judge Chain said, recused himself. The state's attorney, so was supposed to be a board member, recused himself. The circuit clerk recused herself for a perceived bias. The sheriff has recused himself because of perceived bias. All those individuals recognize how important this proceeding is, that there is no taint, because when you decide the question of law that will ultimately be before you, my clients have the right to know that there was no prejudging of their case, that there wasn't a person on that fact finder that was a ringer. We have a unique system of justice. I suppose it would be more efficient to have special people trained in the law that would hear, prosecute, and decide everything. Some countries do that, not ours. Our country divides those jobs. It's, the case that I cited, Samuelson, says it's a unique province for the objector to raise issues of objection of nominating papers. For the Electoral Board cannot raise its own objections to a nominating petition sua sponte. Electoral officials cannot institute an investigation to determine compliance. That would usurp the power of the board, which has the authority to later hear the objection. So when you started that investigation prior, and Mr. Girard raised the objection later, you've acted both as an investigator, and now you're going to be the fact finder. In our system of justice, we have judges, we have prosecutors, we have defense attorneys, we have witnesses. We separate those. We separate those issues so to prevent any probability of unfairness. Any probability. That's how important this is. I realize that this board has already heard, half of this board, 2/3 of this board, has already heard my arguments. Okay? And I'd like to just make another appeal. I realize that we're all trying to do our jobs. And I realize that you may feel that you can be impartial. But you can't be both the investigator and the fact finder. Due process does not allow for that possibility. And it's not harmless error. Again, if you were to do this, you'd be denying my client, you'd be denying the citizens of Will County their right to that impartial fact finder. And when it's something this substantial, due process doesn't allow that taint. We respectfully request that this board consider this and not undergo the exercise of weighing, well, how much bias is too much? I don't know, how much are your due process rights worth? You know, we have a board here that will hear a legal issue of whether to disenfranchise everyone in Will County. You're going to either vote yes or no to give people a choice or to deny them a choice. How important is it that there's no taint for your own validity, for the sanctity of this future hearing that will be coming? Again, we urge you not to weigh a little bit of taint as okay. Let's get an impartial person. Let's give everyone their fair day so that we can have a decision that the public can trust. Thank you.
Thank you. I just don't want to be breathing over our reporters at back here. I think you'd appreciate it.
You're fine, you can go there.
I'm Joseph Serdingle. Along with Scott, of course, are attorneys for the objector in this case. This is a good example of where this case is heading. This case is heading to a situation where the candidate tries to rewrite the electoral code. You've heard various statements by counsel where the Electoral Board, the election code is going to be rewritten at each stage of this, including the determination as to whether there's a disqualification, and whatever happens on the disqualification motion, when we eventually get to the hearing on the substance, which I'm going to go into a little bit here down the road. So we're going to be hearing how that is rewritten at that point. A couple of things I'm going to do is preliminarily, though, so you understand, which are important and sometimes would get overlooked in a case like this. The candidate has the burden in this case on this motion. The candidate has the burden to prove the existence of prejudice, to prove the allegation of damage to the, in this case, the candidate. There is a burden. There is a burden that is on the candidate where they have the duty to show that there has been or hasn't been some impartiality. In this case, we think it's going to be clear that the candidate has not sustained their burden. They have the burden at each stage of this case on each element. And we as the objector, we have no obligation to say anything. It's all on the movement to prove what they are alleging. And we suggest they haven't proved anything. They have proved nothing except statements, unbacked up statements that just are not issues that should be believed at this point. And because of that, because they have not sustained their burden, for that reason, the motion should be denied. The second element that comes into play here is the actual nature of what they're trying to accomplish. The county clerk is the person we're trying to eliminate from this board. And the county clerk is given a special role under the election code. This is one of the first attempts where we're going to be rewriting the election code. The county clerk in this case is given duties under the election code, which include, and you've already heard this to some degree, but the county clerk has the job, has the duty actually, not the choice of her, but has the duty to satisfy herself that the documents which are being submitted here, the various documents are in apparent conformity are the magic words. The statute, I mean, you're going to hear me quoting the statutes because I think they exist and they mean something. You're not going to hear candidate here doing much of this, because they're trying to come up with a new theory that isn't backed up by the election code. Section 10-8 of the election code provides certificates of nomination and nomination papers and petitions to submit public questions to a referendum being filed as required by this code and being in apparent conformity with the provisions of this act. Okay, so who makes that initial gatekeeper review of the matter? By statute, it's the county clerk. Not anybody else. It's not meant to be somebody else that is appointed by the chief judge or whatever we're going to try to do here. That's the county clerk's duty. In addition, the county clerk is the one officer who is the one county officer who is most involved and most familiar with the actual election process in Will County. As you know, there's been other persons on this board that have been disqualified this reason or that reason. There's reasons why these various officers are appointed. It's clear that the county clerk is appointed because the county clerk has the most familiarity and the most involvement with the actual election process. So we should not be so cavalier to just say, well, we can just knock this person off as that person off, and we'll knock off the county clerk too. The county clerk has a job here. And unless it's shown that the county clerk has shown bias and prejudice beyond anything shown here, there should be no disqualification of the county clerk. The county clerk is also the chairman of the Electoral Board. Well, there's a reason why all this is done. There's a reason. The statute sets this. The statute says the county clerk should serve in the capacity as the chairman. She's given that extra authority and duty pursuant to the statute. That is what is binding us here. So before we go around knocking the county clerk off of the board, there has to be some type of an overwhelming reason. They've got to satisfy this burden, which has not happened. So that's two of the important, I think, issues that you have to consider, which are not just necessarily unique to the Electoral Board process. But the burden and the clear presumption that the county clerk should be involved in this process are very clear. So, next step, though, is what is the candidate in this case actually claiming? What is the prejudice that the candidate is actually claiming? And from reading through the motion to disqualify and the affidavit, which is attached to the motion, there are basically, as I see it, two elements that they're using to attack the qualification here. First was that the clerk, their allegation was that the clerk sought the advice of an attorney on the issue of the disqualification of the papers here. Now, as it turns out, because of other conflicts, the state's attorney from DuPage was appointed as the attorney to serve to advise the board, and that's being held against the clerk here. The clerk here did something that she shouldn't have done. I submit that she did exactly what she was supposed to do. When people have issues, when there are questions, legal questions, what's the first thing we say to somebody? Well, go get an attorney to consult with to see what the right thing to do here is. And that's exactly what she did. She didn't just haul off and do something. Consulted with an attorney as to the appropriateness of what the appropriate conduct should be at this point. when faced with what she knows from her records. She is the county clerk. These records are all under her control. So the first element, the consulting with the attorney on her behalf, while it's being held against her, I think she did exactly what her obligation to do was. The second element that they're really attacking in the motion to disqualify is more interesting. I think this probably should be called the 2-minute drill. Okay, if anybody likes football, you've heard 2-minute drills. This is the 2-minute drill that was invented by attorney Edward Wiskowski, where if you take more than 2 minutes, you've taken too long, county clerk, and you must have done something wrong, because these things should only take 2 minutes. Mr. Wiskowski, as the affiant, in this case, apparently is being relied on as an expert who has been doing election law apparently since 1978, and I think that was reiterated today. Well, the only thing I would say is that I've done election law since 1975, and the only thing that gets me and proves for me is that I'm getting old. Okay, and so, well, Mr. Wiskowski is claiming that in his affidavit that from his knowledge, this is something which is inappropriate. There's just no evidence for that. I mean, 1 minute, 2 minutes, 5 minutes, what is the wrong time? What is the time that disqualifies somebody from being able to make a decision? With respect to both of those elements, and those are really, as I read it, the two main elements as to what the attack here is on the qualification of the county clerk. One, that she consulted with an attorney as to the appropriate action, and two, that she took too long. She was just too slow in getting this done. No, the fact that anybody assisted her in doing it, or how she did it, 2 minutes, you're out. Now, and that's okay. That's, as I read their facts, that's the case. That's what they've alleged. Those two elements somehow show a disqualification. Now, you know, the one thing that would have really showed a disqualification would have been had the county clerk said, you know what, I'm not going to accept that. I'm not going to accept that plea. I'm not going to accept that those nomination papers. If she wanted to disenfranchise Mr. Munoz and his supporters, that would have been the easiest thing to do. Just say, I'm not going to accept that. So what did she do? She accepted it. She took the papers, she filed them as if they were valid. Now, as an attorney, and as I look at those papers, and we're going to talk about it in a few minutes here, she could have rejected those papers, because on the face of them, they are invalid, in my opinion. I didn't consult with the county clerk on it. It's not my job. But as an attorney, if I was just reviewing this and somebody showed me those facts, I'd say, you know what? You can reject those papers. She didn't. I could see an argument had she done it. She didn't. So, in my opinion, there's nothing that's shown here that supports the position of the candidate, and surely nothing that satisfies that burden, which is a relatively heavy burden. There is a presumption of impartiality, whether it's in court or whether it's here. There's a presumption of impartiality that has to be overcome by the person carrying the burden, the movement in this case, which is clearly not satisfied. Now, the other thing that comes into play that you're entitled to consider, which I think is a very important element in this case, is the actual factual the factual underpinnings of the case here. What we have is the argument is, as I understand it, that the county clerk was prejudiced and is attempting to do something to control the outcome of this case. You don't need to look at anything in this case other than the actual facts. And the first fact is that the candidate here, Mr. Munoz, voted as a Democrat in the 2020 primary. I don't think there's any dispute on that part. But he pulled a Democratic ballot in March, I believe it was, at the time of the primary. Okay, so we got that fact. That is a fact. The county clerk hasn't tried to control that, hasn't tried to change it, hasn't gone around it. That's a fact that's in the record. Second thing is, the second fact, more or less, is that in section 7-61 of the election code, there is a procedure for filling a vacancy if there was no person who was in the primary, who was elected as a candidate in the primary. Okay, so we got that. In this case, it looks like the Republicans attempted and have done the paperwork to qualify Mr. Munoz as the Republican candidate for state's attorney in the general election of 2020. Don't think there's really any fact about that that's in dispute. I think that happened. Third thing that happened is that, and I'm going to do a little bit of reading from the statute, but I think it does come into play. Section 7-61 that I just referred to provides that the person who is filling this vacancy, supposedly, the person shall file his or her nominating petitions, statements of candidacy, notice of appointment by the appropriate committees, and receipt of filing his or her statement of economic interest. Okay, so you heard the word statement of candidacy. In section 7-43 of the election code, you're going to notice that I'm reading a lot from the election code. The other side is not. That's because the actual language of the code doesn't help them. But section 7-43 of the Illinois election code provides that a person who voted the ballot of an established political party at a general primary election may not file a statement of candidacy as a candidate of a different established political party or as an independent candidate for a partisan office to be filled at the general election immediately following the general primary for which the person filed the statement or voted the ballot. So the critical part of that is that a person who voted the ballot of an established political party at a general primary election, which is what happened here. We had Mr. Munoz voted as a Republican, as a Democrat, in the primary. But a person in that situation may not file a statement of candidacy as a candidate of a different established political party. That's what the statute says. May not like it, may think it's not fair, you may think, oh, we should be able to do something different here, that's not good. Doesn't matter. That's what the statute provides. Now, I did hear the other day counsel for the candidate here made a statement. Now, I may have misunderstood it, and if I did, I apologize, John. but apparently there is some theory here that 7-61 relieves you, filling the vacancy, that somehow that relieves you of filing an appropriate statement of candidacy. That it's different because it's under 7-61 as opposed to just being a regular candidate. There's nothing in a statute that says that. Nothing anywhere that says that. Okay? The statute makes it very clear that if you have, in this case, voted as a Democrat, you cannot now file a statement of candidacy as a candidate of the Republican Party for that same office in the same election cycle, which is the general, which is coming up. You just can't do it. So the point that ties in with the disqualification here is that the county clerk didn't control any of that. That was all in the control of the candidate, the Republican Party, whatever, who was putting things together here. There's not a question of whether she lied on something somehow, or hid something, or removed some files from something. There's no proof that she did anything that would be a prejudice or a bias to the candidate. The only person who did anything which hurts the candidate's position here to be able to run in this is the candidates and the Republican Party that put together the vacancy, the resolution to fill the vacancy. So what we suggest is that given the various things I've mentioned, the burden that exists, the disregard for the language of the statute, actually, the claim of some type of bias or prejudice which is directly contravened by the fact that the county clerk allowed the papers to be filed. If you put all that together, I may not have said it very artfully, but the fact of the matter is that there is just no proof that the candidate has satisfied any type of burden here to be able to remove the county clerk as a member of the Electoral Board. Thank you.
Thank you, council, members of the board. Mr. Schnugel has just asked you to consider the factual underpinnings of their objection. And he went on and explained some of his legal theories, which obviously we object to, which we disagree with. And that at some point will be decided before this board. But the case law at this point isn't his objection. The case law at this point, Gerard, states no matter what the evidence was against the defendant, he had the right to an impartial judge. It also states that it's the well-settled principle of law that due process requires that a party appearing before an administrative tribunal be judged by an unbiased decision maker. So that's the issue, not the legal arguments that we're going to be making at a later date. Do we have the right to unbiased decision maker? Mr. Schnugel put some high burden, that because of the presumption of impartiality, there's some high burden, it's clear and convincing, it's beyond reasonable doubt. The high burden is that of integrity. The high burden is no taint of impartiality. Because the protection isn't for you. The protection is for the candidate, for the party, for the voters of Will County. And it's not just actual bias. It's the unacceptable risk of bias. How do we demonstrate that? One way of demonstrating that is, did you do something different from how you do everything else that you've done? 2-minute rule, I don't care if it's 2 minutes or 20 minutes, did you treat my candidate and my clients the same? If you treated them differently, it suggests bias. Did you give 20 minutes to all the 318 people who filed applications? Did you seek legal advice how to keep a person off for all 318 different applications that you accepted? Again, I think the fact that you acted prior to it even being filed demonstrates bias. It wasn't even filed yet. You're there, hey, how do I keep this person off? How do I keep this person off? How do I stop the voters from having a choice? Again, prior to the filing, at a minimum, that suggests either coordination with the objector or you're acting in your own part as an investigator. Even prior to the application being filed, you're doing affirmative steps, unusual steps, steps that you don't do in any other case to keep Mr. Munoz off the ballot, to block access, to deny the people of Will County a choice. Ballot access is a substantial right, and the due process right to an unbiased decision maker who doesn't have an undue interest is important. It's not lightly to be ignored. The affidavit of Mr. Rinkowski, while it's not quite as, he's not 45 years like Mr. Snoogle, that affidavit is unrebutted. They didn't have any other affidavits of any other experts to assist you, to tell you, no, sometimes on one particular candidate, you'll spend 20 minutes. No, that's unusual. They didn't rebut that. Again, you can't be both the investigator and the fact finder. You didn't wait to see the objection and then now you can rule on the objection. You had the objection yourself. You had the very same objection. And now you're going to decide that very same issue as the fact finder. It can't be unbiased. You had that very same thought. And the fact that maybe your counsel said, no, you have to accept it because that's your job, doesn't mean you're unbiased. Again, let's not taint this process. Let's not hold this process up to ridicule. Because if you have to make the very difficult decision that Mr. Munoz doesn't belong on the ballot, if you're going to disenfranchise everyone, you better make sure that the people of Will County can trust your decision. They can't trust your decision if you're both the investigator and the fact finder. Thank you.
Madam Chair, the parties have presented their legal positions on this motion.
Assistant State's Attorney McCarthy, could you please provide the Electoral Board with your legal opinion on the issue of if the Will County Clerk should be disqualified from the Will County Officers Electoral Board in this matter?
So, in a motion to disqualify, the burden of proof or persuasion is on the movement. In this instance, the county clerk is presumed to have been qualified to serve upon the Electoral Board, barring facts which indicate dishonesty, personal interest, or other serious bias. To prove bias, in this case the candidate, must overcome a presumption of honesty by showing in the record that the administrative proceedings were either tainted by dishonesty or contained an unacceptable risk of bias. The candidate's motion is accompanied by an affidavit which purports to contain allegations of bias by the county clerk in the acceptance of the candidate's nomination papers based upon the affiant's personal observations and past observations of processing nomination papers. To the extent the candidate has shown any risk of bias, he fails to do so beyond the level of potential bias which the statute necessarily implies into the duties of the county clerk, both in serving as the chairperson of this electoral board and also in processing, receiving, and handling the ballots in the election paperwork. The statutories of the county clerk require our office to participate in the acceptance of nominating papers. As part of that acceptance, and the law is clear, the clerk must review such nominating papers for apparent conformity with the statute, and that's 10 ILCS 5/10-8 and 10-15. So in performing her statutory duties as the, quote, gatekeeper to turn away nominating papers that do not even purport to conform with the law, close quote, and that's from Samuelson versus Cook County Officers Electoral Board, citing North v. Hinkle, a 1998 appellate court case. The best the affidavit can claim to allege is that the clerk obtained some familiarity with the facts underlying this matter. It's well established in Girat v. Keith that such familiarity does not disqualify a decision maker. Such familiarity does not establish a sufficient risk of bias to disqualify the county clerk from sitting upon the Electoral Board. There has been a lot of discussion today from both councils regarding the time limit. The Electoral Code does not set any statutory time frame in which a nominating paper must be reviewed. It doesn't require 2 minutes, 5 minutes, 10 minutes, 20 minutes, an hour. It simply says that if it's not in apparent conformity, the clerk may have the opportunity to reject it. As I said, such familiarity and the inherent interrelationship between the statutory duties of the clerk as the chairperson of the Electoral Board and as the gatekeeper for nominating petitions, it doesn't rise, in my mind, to the level of bias contemplating a recusal or a disqualification as a member.
Okay. Based on the arguments made by the parties, I will entertain a motion to either grant or deny the motion to disqualify the Will County Clerk from serving on the Will County Officers Electoral Board. I will not vote or participate in these deliberations.
I'll make a motion to deny the petition.
I second.
Just so I understand, that's a motion to deny the motion to disqualify.
Correct. Discussion.
A motion has been made and seconded. Is there any discussion from the members of the board regarding this matter?
Please. I think in this case, that I accepted the decision of the state's attorney to recuse himself. I understand it. I respect it. I understand the situation where the circuit clerk recused herself, and subsequently the sheriff, as well as anybody else recused himself from this board. Those people had time. Judge Shainstead had obviously reason and time to consider. In this case now, the county clerk has had plenty of time to consider whether she should recuse herself. She has made the decision not to. Based on what I've heard today, it appears that her actions were consistent with the oath of office she took to perform the duties of Will County Clerk. So if she were to recuse herself, I would respect that and accept it. But since she has not, I think we should move forward with the case.
Is there any other discussion? Okay. All in favor of the motion say aye. Any opposed say nay.
Aye.
The motion carries. That concludes the ruling on the motion to disqualify. Based upon that ruling, the board is prepared to move forward with the objection. Would counsel, for the candidate, like time to prepare? Do we want to schedule time for, do we want to schedule counsel? Do we want to schedule?
Would you like to?
I plan on filing 5 minutes to move the petition for judicial review. I previously tendered a copy. I can tender copies of them.
Mr. Ivey, just for the record, I actually can't accept service on that because I'm limited in my role as the board's attorney for these proceedings. The judge's appointment of my office as special counsel does not go to any appellate work. He was very clear about that. We view this as appellate work. So I'll have to contact someone to get an attorney appointed to the board. I will communicate whoever that is to counsel. But yeah, I'll notice for the record that you serve the members of the board individually.
I previously also moved the exhibits. I didn't make another copy of all the exhibits. If you needed the copies, I'm happy to remake them. As far as for dates moving forward, we want to schedule this for a hearing, and then I presume the judge is going to, between now and the hearing date, rule on my petition for judicial review. So again, it's the board's discretion what to do.
I'm somewhat unfamiliar with what pace matters move here in Will County. Would you imagine that there would be a ruling by Friday or that
So if he wants to hear it this afternoon, hear it this afternoon. If he wants to hear it tomorrow or Friday, he'll hear it tomorrow or Friday. It probably makes sense to set the hearing on the underlying objection Wednesday of next week. I think we had a conflict.
I disagree. I think that we're gonna get a ruling relatively quickly on this. I think for reasons that we previously discussed, I think that everybody was available for Friday afternoon. I think that the judge will give us an expedited ruling on the candidate's emergency petition. And I think we need to set this for Friday because we are getting to the point where it's the electoral board process is being extended and extended and extended. And we're going to run into difficulty where we have the real petition for judicial review is going to come into play and cause problems with the printing of ballots. So I'm suggesting that we have an expedited schedule that we set it for hearing on Friday. If something happens, we can obviously, if there's a ruling and there's got to be something done, then Friday will be, can be dealt with then. But I think we should be proactive in getting a decision on the objector's petition, and I would ask for Friday.
Madam Chairperson, I suggest a recess for 15 minutes to see if Mr. Ivick can get his decision. We can recess at that time.
I think that makes sense. If we wanted to do a brief recess, Mr. Ivick can file his petition. You can see what briefing schedule the court's going to give him, and that can inform us on how we move forward, because I'm inclined to agree that if we move forward and then the court rules that there's reverses the ruling of the board with regard to a motion to disqualify, we have to go back and do it all again anyway. So I think it's a smart idea to take a brief recess. Mr. Ivick can file his motion. The councils can get a briefing schedule. The court, in that matter, can give us an idea on how quickly it's prepared to rule, and we can work our schedule with that knowledge. So I suggest a motion for a brief recess where we can resume in approximately 15 minutes would be a good idea.
I'll move to recess for 15 minutes.
I second.
All in favor say aye, opposed say nay.
Aye.
Aye. Motion carries. We'll be in recess for 15 minutes.
Thank you.
Very good. I'm going to find out what this is. Counsel, is this under Judge Simon?
Sorry.
Which judges are you?
Carlson was who the order said that had to keep track of.
Okay, so in that case, what I'll do is I'll go up with the council just to reflect that, the limitation of the prior order from Judge. Starting with last night. Carlson or Shane, who's the one that wrote the telephone here? Judge Rickman, sorry, thank you. Wait.
Oh, I know.
Is someone going to be here?
Somebody will.
Not that I think that somebody's going to swipe the county's laptop.
What did you say?
I might take it.
It might be nice, right?
Okay. I don't have it. What do you want? Okay.
Yeah, we had, I'm not kidding, there was a period of 2 or 3 weeks, 2 weeks probably, the phone, I don't know, the phone rang once. It was serious sketchy.
Well, I guess we got to follow
We still think that they can't buy a car legally, or they can't, finance or whatever. They have this whole scheme where they beat these folks. And we have one case right now, and another case that they want us, another person wants us to take, same car lot, same deal. And, it's barely at a level where it makes any sense to hire it. And somehow the clients decide to go ahead and pay us. And we're not making a ton of money out of it. It is a lot. They run after this for a long time, and then they get, in trouble, they shut down, they open up a new maintenance. I know those well. We've been working on them for a long time. Delay, don't pay. But you're mainly trying to pay along. It's the pay and the consistency of paying loss gets you that. I think it's probably one of those things where when it comes in, take it. But, no? Really? What? Oh, right. Yeah, no, we have, Nick in our office is doing our criminal cases, and he enjoys it, but that's, here's the deal. His record is in the basement. It's terrible. We have a case right now where a client of mine was drunk. They were at a party. His wife had a medical emergency. Fire department called. Fire department comes, takes care of her. He wants to ride the ambulance. They tell him, no, you can't ride the ambulance. You gotta get on the ambulance. And the firefighter said, "You really big dudes." Big guy. And this guy got mounted with him. And so they're keeping him with the ambulance. That's right. And so, long story short, I had a firefighter. One of the nicest guys ever.
So you got it.
So, I told Nick, I'm like, yeah, you need to tell him if he needs to say he's sorry, or he needs to really mean it. Because this is one of those guys who he'll probably let it go. He'll probably be like, I'll kind of clean out kind of a minor issue, give him some fines, some time. It'll probably get worked out, but he's one of the nicest guys ever. It's one of the worst decisions.
Really, I've got 4 or 5 clients right now who've been diagnosed with schizophrenia.
Well, no, you could have a person declared disabled, but then that comes with a whole set of problems. I've had a couple times over the years, we went to testify, and we had to fight proof to court, and ultimately the person was basically declared as incapable of testifying, which meant the Dead Man's Act applied in civil cases. So block the other side, right, this one. Kind of use it. It's a strategic. But there's a reason for it. It's legitimate. Yeah.
No idea, my calendar is not coming up.
Come along.
Sherry, not yet. Absolutely nothing on my calendar.
Oh, no. That's not good.
I mean, nothing. I've shut my phone off, I've reset it. I'm like, why am I not getting anything?
I wonder if there's bad service in there or something.
I know there is. Because she's like, do you have anything Friday? And I'll be honest, I know I didn't because
Yeah.
I'm supposed to be at my sister's pool on Friday. And so I know I have nothing Friday afternoon.
But it's still within.
But, yeah, not one thing.
It's got to be the service.
I know it is. We have a couple minutes, right?
Yeah.
But, so, I mean, the building itself had been made for 8 years. They don't do anything. People really like the building always. Had replaced 20 windows that's been done there. The seals had kind of busted. There were holes in the roof where it would rain. You just stood aside, rip.
Hopefully we get some of this stuff soon.
There's lots of stuff. There was a blocking the emergency exit. There was stack of stuff blocking the door, like it all drains out. So we've done a lot already.
So you have the two customized versus pipes.
Tell me that.
Oh yeah, it's terrible.
Yeah.
It's like directly.
Yeah.
Yeah, I mean,
I
it's,
wonder what the decision.
how I got there? Well, one of the keys is finding a piece of property license.
Three over, that's.
They do it for backyard. The place that we're at now, we have a tremendous deal for rent. I've been there for 13 years, and the building has problems. It's 5K cheaper than everybody else in this building. Wow, good. Per square foot. But it has issues. It's always had issues. I've dealt with a lot of this stuff. Just like I just had to do it there. So you go to I've lived every time I was
Yeah.
the cost of this is it's about 25% more, 30% more maybe. And then if I rent out the other side, which I do, it's going to cash flow better, it's going to be paying less than I am now. So, there you go, the cows. Now, the cash flow is
Nothing on my phone for my calendar. Oh, really? But I know. Yeah, no dogs. I think that's not accurate.
I will say, one of the lessons I've learned with Richard, we had some cases that turned out.
What are you doing with it, man? Dude.
And that's part of the deal. I had a fabulous year.
I can see that. So,
He's a good lawyer.
yeah. Yeah.
I have 150 comments his work product, but his clothes. If you can get past that,
long as the member of the public.
He pulls his finger out.
Nah.
He starts to run away. He turns back, and he aims it at us. The officer then drops his taser, grabs his gun. He's still running away. He got fired. Black guy was running away. The red yellow running away. And then as soon as he saw it, he dropped his taser and grabbed his gun. So that's what he was. Yeah. My first, this is like February. You know, the police county is doing it now where the felonies and the seniors, it's on their attorney. Yeah, well, McHenry's open, but the bathrooms aren't. So Corey is moved there earlier this week, and she has a bathroom. I don't think she's gonna tell me.
They have to find out when.
Yeah. I'm sure there's a excessive movie issue. Yeah.
Bristol.
Yeah. Right now, I'm in one in court. My judge is so valid. You know, it's funny you say that, because I'm thinking, well, that's what we have to do. Currently, we have $20. And when we switch buildings, we lost $7. We know we may upgrade it further from there, because our funds is going to switch over and some other stuff, but somehow, I don't know, we haven't had tech issues with that. Now, we have hall lines to every office, wherever. Oh, really?
where did it all go? And I'm just, I'm giving it, and I'm giving it to the courthouse. I'm just giving it about the courthouse. Right. Okay, I just wanted to make sure.
No, I tell you what though, my wife talked me into buying a pool. So, it's a boat. We're gonna have a party here, and hopefully it looks nice, not trashy. She literally says to me on like Saturday. Pool, the kids are young, we want to use it, we really want to take it very well. We could do it so it looks nice. I messaged a friend of mine, we just going in last year, like, it cost you.
Right.
Now, everything we do is more expensive, guaranteed, every time. So I said, we could get it for $15,000, yeah, sure. That was on Sunday, I pulled it out. Monday after 12 o'clock, she calls me. She wasn't. We're not gonna get it till later this summer. And I don't even know if you
On the
this year.
20th? Yes,
But, so that's our summer vacation, I guess.
because I want to
You were supposed to go to Sweden.
system and it,
They were in
you know,
Sweden,
make it out.
and, yeah, so they were gonna visit some relatives for a couple of days, and then we were gonna do a week-long cruise, and I think she and stuff like that. But, that's been kicked to next year, hopefully by then that was whole must be over. Yeah, I think it needs to get on international, to get on a boat. Oh. I've got a friend who's been on 4 times too long for ocean since he saw him. She actually Right. Selling into restaurants
Right. So I said to my husband, "How big of a piece did you get from this?" Just a small crust. I'm like, I ain't even next to you because these are full thing. Right. So that's why. So, in a good way. Just bring it up. It's just, he's got just kind of gave each other crap. She was, we went to Christmas, we should do it. So we're out there, we're cute. And then we went to oh my God. She's been a figure. So I'm jealous. What can I do about it? So, walked in the other day, we walked up and she was at her computer. Because when she sits at her computer, she's working. She looks like so we walked her. He's like, "Oh, you're married?" She goes, "What? You can't say I'm just working." So, oh. I didn't say that. So she came in and says, "One man, he's had a complaint against him." I said, "They told me about this." She's let him think he's getting in trouble. And so he would call her and she's like, and he goes, "Amy almost pulled it, but she smiled at one point." And when he walked out, he walked up by Laura and he's like, "Really?" And I looked at him and I said, "Gotcha." And he goes, and I did look at it, Laura, and I go, "You do know it's a payback now again." She goes, "Oh, I know." He goes, "It will be good, Laura." So it's fun that there's like fun. Yeah. Because for a long time I didn't have any. Like I know. I almost didn't. No. Like, oh, I know. So. I didn't realize. That's my first Halloween that I came costume, which is customs.
Yeah, I don't know.
Every one of them. That's great, though. Had I known it, I thought it went out under the good gosh. If I would have had any inclination that that was going to happen, I would have wanted to rent a full one under which it came in all the way. I would never. Oh my God. Probably like a Bears jersey or something. Like, but speaking of this.
Did the governor declare that the election day is a holiday?
Yes.
You gotta be open. I gotta be open because it's payment due date,
Yeah.
so we can't take it off. So now you gotta give people
I'll
count.
be thinking of it
Thanks a lot.
because I do believe I can qualify. And I remember when I worked there,
Yeah.
it used to be. Because I remember when you remember that I remember being off a couple times for
Yeah, I think the city closed all 2 days.
Or no, I haven't seen Hydro Hair. So I don't know what to do.
Are they in a public corner or?
I don't know. I really don't know.
You worked here. You didn't work here.
So
Were you here?
I was always on 305 because status quo for aggravated traffic.
Oh, no. I mean, I work here in the recorder's office. Here.
No, my mom was never here.
In this building?
Never.
Yeah, I work with her.
No, I'm telling you. She started out in Duffy's office when she worked for Jim O'Connell. It was in Duffy's spot in the county building right next to Warren.
That's what I just said. James J. Jim O'Connor, Will County
Yeah.
Recorder.
But you said here.
Here in this building.
No, not this building.
Yes.
The county building.
No.
No, I'm telling you. It's never, ever been in the courthouse.
I work here.
I have no idea.
Jim, I would guarantee it.
Okay, what do you want back?
I will bet you it's my year's salary.
Guys, these are minutes of our lives we'll never get back. Listening to this argument.
No, it was in Duffy's office.
No. It was right here.
Oh my
Never.
God. Will someone just concede?
Yeah.
I won't, because I know. And then my mom moved to the basement
No.
of the county building,
Tim says you're wrong. Tim says
Yeah,
no.
and then they went to
the
the
executive center.
Amerifed building.
Right.
Executive Center.
And then they went over to Warren, and then my mom moved over from the county basement to the executive center, where I was in. And now we're in the social security building.
Let's see, how am I gonna put this? Gotta find somebody old enough. Let's see, I got out of college in '84. And I went to work for James J. Jim O'Connor. In this building. I got that end of the building. And second or third floor. Second.
How long did you work?
About 6 months.
Then maybe before my mom worked there.
And your mom worked?
Not in this building.
Yes, she did. I worked with her.
She didn't.
I worked with her. She was a new hire.
Hang on. I got this.
Yeah. Who will know that? She started there in the fall of '84.
You're better than that on me, because that I didn't know.
Yes.
Wow. Yeah, it was a circus. Yeah, well, that's why.
Hey, Barb.
Yeah, they had a,
When mom worked for
what do
Jim
you call
O'Connell,
it? Attorney, just got his license.
where was the recorder's office at?
Supervisor. 7-Eleven. So that was the guy handling it. And the city attorney, for the most part, was off.
On the first floor, right? No, not when she worked for, when she worked for O'Connell.
Yeah, that's where she worked.
On the first floor.
No.
No, she didn't do that until after she got elected.
But she was on 2 hours, 40 minutes. Yeah, it's not true.
But was it ever in the courthouse?
We came across, I don't know what that road is there by the racetrack.
Okay.
On one side of the.
I'm arguing with Tim Brophy, because he said he worked with mom, and it was in the courthouse, and I said, my mom was never in the courthouse. I said it might have been there before she started. But I just wanted your memory, so I'll call you back. Bye. Who are you calling?
Yeah, it's not bad at all.
Text.
I have someone, Peggy's worked for the county for 25 years. Peggy, that works for me.
That's not long enough.
Hey, Peg.
35 years ago.
Okay. When you worked for Nancy, or in the county clerk, didn't the recorder's office used to be where Duffy's office was? Before it moved to the basement? Okay. Do you ever remember, okay, you don't ever remember being in the courthouse, do you? Okay. Okay. Not old enough. Okay, do you know anybody that's been around for a long, long time? Lori Costello, she don't work for me anymore. Because Lori worked for Jim O'Connell too. Okay. Never mind. I'll talk to you later. Bye.
A little different down south.
Did Lori Costello work there when you worked there? She would have been there 32 years.
And this is 36.
So my mom started there when?
Following,
The actual corporation was started in 2011. We've been doing this type of work since 2010.
She had been there in 88.
It grew into
Against
actually,
him?
we got what's called American
she
Watchdog.
won.
National Foundation for trained local government.
And then he lost in the primary in 88.
Mom won.
No, my mom lost in
Oh,
88.
she lost. Oh, then the
It was Shirley
recorder was-
Costa
The answer
Yeah.
is there.
and my mom running. So Jim lost to Shirley.
Yes.
And that's year my mom lost by 14.
It's amazing though, the number, especially right now.
So she won in 90.
Smaller
Yes.
local public bodies will just refuse to give people any rights.
So there were a couple of
No, you're not coming to this.
appraisals that came in for
We'll
green
give them
sheets.
access to it. No, we're
I
not
was
doing it.
filing green sheets. This
And
monster
then,
machine was
okay,
there,
you're forced to
doing
hand.
all that. Make copies for Vegas and someone else.
You didn't work there very long.
No, it was just
Like a summer? Okay.
we got out of college until,
We did like 2 weeks.
Okay.
so May, around. I might have
When
went
that
to,
hurdle, and then if you're gonna record, you have to have,
I was there too.
sign this sheet,
Spring.
gives you permission
Or the,
to record, but you have to display it in full. You can't edit, cut it, can't do anything to it. It has to be in its entirety. It's like, folks, you can't do that to people. But the level they go
Oh,
to
you
is
can.
amazing. And usually those are the
got your
places
salary coming if I can pay this.
they're doing stuff they should.
You're a witness, Brenda.
No.
She better salary.
It's so easy just to do it right.
She didn't say how long it would take to
There's
give
a lot
it
of
to me.
them.
A buck.
Eventually.
And I'm
Buck a
making it
month.
very clear that when my
The
mom,
ones that always end up in
that
the articles are the ones that just.
it was where Duffy's office, it was small.
In the current county building,
In the current, where Duffy's office is.
auditor was
Used to be a-
downstairs.
I don't know where he
I
was,
think they were downstairs.
but there was a big window right where Duffy's glass windows are, and that was the recorder's office.
Okay,
We had one down
yeah.
south
Well,
of
no one
Richfield, they put a sign up on the door. Until further notice, we're no longer
Yeah, I don't
accepting
know who
requests.
else besides.
Somebody sends us that picture, it's like, okay, now we get.
Oh, you know who would know?
This one.
Chester Newcomb might know.
We got the
Roxanne,
records.
Slocum, Mary
No, this
Scott.
was,
Roxanne started out as a title searcher.
there was some corruption, actually the feds had got involved, some people got indicted. They were gonna keep the records.
Andy
They
June.
wanted to let everybody know what was going on. And
Yeah, Cindy worked,
Cindy,
Just.
Cindy June was the chief deputy.
she started, you call Cindy,
Their own family
call Cindy and
members
ask her where the recorder's office was, she'll tell you. East wing, second floor.
How long does it take to get a hearing date?
I don't think there's a lot of judges here in the afternoon.
Do you think they're actually having the hearing?
I don't know. What were you supposed to play?
Yeah, but-
What time did you play?
If they're the one who's
It's still good.
recorded
It started
the hearing, but yesterday.
18 with the guys who were supposed to do that.
Really? It'd be nice to have a transcript though.
I was given Chuck a hard time. I was reading everything that they sent me over yesterday, and they have the transcript of my Chuck gave us. And I do this, and I didn't realize, it's like, you know. Because I thought I was very articulate. He goes, well, thanks for bringing that up, Karen. And I was talking to my sister for
He does a lot. Kevin Collins is a nurse. So annoying. He doesn't even say, no, he said, no. No.
Well, one of my first conferences I went to, some speaker didn't show up, so they asked another guy to give a presentation on property fraud. And I knew Mark from Fiddler, and so he's doing this. And he kept saying, and at the end of the day,
At the end of the day.
and it got to the point where I was sitting there through this presentation going like this. So we got done, and he says, so how did I do? And I said, well, there's two things. I said, first of all, I walked up because the whole time he's doing it, his tie was crooked,
Yeah.
fixed his tie.
Yeah.
That's what bugging me.
B,
I go, and I don't know if you're aware of this, but I'm like, you said like at the end of the day, like 35 times.
I've aged 2 months.
And he goes, do I really? But then I became friends with the recorder from Lynn County. And I'm talking to him about lunch thing one time, and I didn't pay attention. Him doing the little marks, he told me what I say all the time, and I don't remember, but for the longest time, I made sure I didn't say it.
Free and check several times. Yes, it was, you know, really loud.
But I knew the presentation for property fraud, but when you hear it at the end of the day, like all of a sudden you just tune out everything else they're saying, and you just start counting.
None of the antics anymore.
Make it always.
Different person.
Don't be stupid.
Chuck goes, but I thought I was being very articulate. He goes, but thanks for letting me know again.
What or is he going with this?
It's a hesitation for thought. And instead of silence, it's actually just be silent. Many people do that. It's not necessarily, it's a sign, depending on the complexity of what they're saying. It's a sign of intelligence. It's they're basically taking the time to process it. But he actually don't know what it is to say.
Yeah, it was, yeah, it was 5 hours, just over 5 hours. I could not believe how long it went. We're just sorting out. With one. No, I'm not kidding.
I'm trying to find a judge, but I don't think there's many judges here in the afternoon, especially at 3 o'clock, or even 2:30 at that time.
Yeah, it was,
I can tell you, Judge Ashamble just left when we walked out.
comical part was most of the officers there, the bailiffs, the city council, they've all had, and they just could not believe what they were They're either all related or they're fighting with each other.
Nancy Schultz lives with
No,
me.
the state's starting out there.
Sure.
We walk in the church out, he's like, oh, hi, Joe, hi, Bob, hi, Mike, hi, Valerie. Half the empty, you have the empty. It's like, oh, God. I'm like, oh, this is not this, right?
That's about how it is down where we're at. I mean, anybody knows everybody.
That's what I was like.
Now we're at an hour. I knew that 15 minutes. I was going to say 20. Just generous.
Well, it's been an hour now.
Well, this is probably the first and last time we'll get to see our electoral board. The other, Jim and Andrea,
Oh, they'll be back.
they're doing, well, the other ones, we're just doing this one. And they can all send delegates.
Oh, that's funny. That's the way, no, it's
Where are you doing those?
6-5.
Oh, in here, all of this?
I don't like sitting around the side.
Well,
It's too bright.
oh, I know, it's terrible. There's no, you can't sit up there, there's no,
Yeah, this is just like,
this is
they're
brutal.
on a great side. Can we switch sides?
Yeah. Them in position being the chairperson, should have water and snacks in there.
That's my bad, I probably should
What's that?
throw everything else. I'd like to make a motion, but I can't. I don't think I'll take this one.
We never do.
True.
I went to McDonald's
We
before the
underestimated
guy.
him the first day. His job all the way along. He's going to be coming in late.
They have vending machines out there. They don't have any, oh, I said, they don't have any hand sanitizer.
No, not a lot. Movement?
Yeah, let me see if I can get Mr. Cernugo.
Do what? That for nothing. Dang. The vicar? I called him, just making sure I have nothing on my schedule.
Oh, that's
Friday
good.
afternoon. Because I can't speak for you personal, but. Yeah, well, I'm just gonna read it.
We're just going to set a blanket.
Set my name. Whatever happens in So what?
What day did they?
They like, Friday at 1:30, Monday at 11.
I don't think he could.
Yeah, I agree. We lost me again.
They were just there.
Where's that?
Would you get your nails done? You used to do that?
Really?
So I used to have her husband, and then he left. Because his brother opened one, but it wasn't nearby. And then when they reopened, no, she's not there. So I'm trying to find like my next place. Centerville. Okay. That's how Kelly was. Nothing worse than going somewhere and just being like,
Noted. It's noted.
Sherry,
He's all over.
Yes.
my friend has anything on it.
Just have them in our sites.
Is there some,
Thank you. Good to know. But I was looking forward to him being around this year, because then I always had someone to help with the dogs. And then I don't have to run all the way to Shannon. Right. Because originally he's like, this is going to be a couple months. It's been a year. So now, so it had to be like April this year. And I looked at him and said, you're not moving out till at least December 1st.
We don't need them. We can adjourn.
So when I checked, called to ask me if I wanted to do this. I said, why doesn't anybody else want to do this?
You're all the way to one. You didn't imagine that first and sheriff is second. There's no name on the number. Is he sure?
There's always Duffy left. How's your office doing, being okay? I like, do you have two windows in the doors, or just one? Really?
The window on each side of the front door, and the other one over there by that door. That's kind of.
That was a great idea.
Not one of those people.
I don't blame you.
Works great. Got lucky with light and went outside, but it wasn't.
And you had decent weather.
The one day was hot, so what I did was I go out there and I said, anybody over 65? Come up to the third window and I took every person with their fingers so they could stay in
And
air
air conditioning.
Nobody said a word.
And you know something, if you did, you're just being a jerk.
Somebody did say, I'm 64.
Well, yeah, but it came.
Why do we cut it off? He's 63, 62.
Yep.
So I did that, that helped. It's really not helpful. The guards had to tell people we had places to stand, and then after that, they had to tell them to spread out a little bit once in a while.
Well, my girls, when they first came up, Connie came over with the things for the front counter. He kept saying, well, what if somebody comes in and moves it? I said, can I whisk you something? I go, ever into a place and went, hang on a minute, this is in my way.
This doesn't fall away.
They're like, no. I go, do you think everybody should use trains? I went to Morris yesterday, 2 days ago. I was in Morris. I went to pick up dinner. They have a great little sandwich shop called Corleone's. I parked my car and I walked in. People walked in and they got all the seating outside. No one wear a mask. So I went there and I got a mask. There's not one plastic shield and not one person cooking, doing anything, just wearing a mask. I go,
Kelly, they think so.
it was so bizarre.
It was so normal. It was bizarre.
Yes. But I mean, you guys don't have like any other.
You're still waiting, apparently they are trying to file it again.
I know I don't have to be here all night. I know the corporate board doesn't deserve to be here all night.
No, we are.
And I even looked up where all the definitions were too.
You let me know. We're here. We can close this thing if we want to.
I was telling them, I went to Morris to lunch and dinner the other night. And Morris is a whole new world.
Oh, yeah, anything.
Any shields? They don't wear masks.
I know.
I'm like, it's like I'm in another state. Literally, I'm 15 minutes from my house. Who does calls out loud? I don't know. You okay?
Yeah.
hours past the time, and I'm already gone.
Yeah. I know that.
I think we're going to
All right.
12 minutes lunch.
You should do the drop.
They don't. No, 100%. All right. And I order everything special. I get ketchup only. So that I make sure.
Little did I know that every time you fill it, you're a thief. So, that was my process of thinking.
You just file the motion. Huh? They probably have to do it electronically. They said they can buy e-filer. So, now they're talking. And in the chief judge's office. Sarah and the judge just left. Hardy's out there now. Judge Hardy. Hardy's too. I could sit here and put games all day. We're losing people just.
Sir? I don't have one on me. I can jot down my name and number if you want. You bet. Minutes is up.
Yes, way up.
Okay, you don't have to go there, just.
I'm saving my
For college?
kids were 8 envelope students. I would invest, but my boys.
Are they playing football or?
Yeah, he just texted me that I have to, they're allowing something. We have been cleared for in-person workouts under stage 1. So I have to sign them up for something or other. And I'm like, tell your father I'm in court.
I know my kid was supposed to start this week, but we pushed it off
Yeah.
to be in person.
Okay. Is he doing football?
No, cross country.
Cross country. How's he like that?
Loved it.
Yeah.
Last year he was very iffy about it.
Yeah.
He fell in love with it. He was in love.
Yeah. Well, I made Frankie chili when we were at St. Mary's. And the Kuklinskis were running the program. And I tell everybody, listen, some kids have done school. And this is the first time they've done custody. This is the funnest school I've never been exposed to it, but just the whole camaraderie of the whole thing. That you're like, I just,
No, it's a
it
lot.
was just so fun.
You know, and I kind of just told him, try it out.
Yeah.
And that's all I can tell him. Just do it himself, because
Yeah.
he's loved it so much.
Yeah.
Which was really
How's Lauren?
She's doing well. She's on travel soccer,
Okay.
still with
Okay,
Chicago
still
Fire.
at soccer. Okay.
And they're finally,
now, we're up to like 11 and 11 now, so we got my one team left now in our age group, so
Yeah.
now that she loves it. She just goes outside
Yeah.
morning, she's outside.
We had friends, I can't remember well, my nephew's in Barton, he just got a scholarship at One Central. They wanted him for Ohio State, but after talking with other kids there, he was afraid to get so he chose to go to One Central. Yeah, so he wanted to.
They go to school before they're going to play with it. The kids are close to it. You know, they're so bad tonight. Wow, it's early May.
Yeah.
What you do, I call it pace workout. It's like, you know, I'm trying to teach them pace.
Yeah.
You know, so, because I used to do that when I was in high school or college,
Yeah,
so
yeah,
I kind of understand how to do pace.
Yeah.
Understand it.
yeah, yeah,
So, now that it got hot out,
yeah. You gotta wake up early in the morning, yeah.
he doesn't want to do that, he wants to do it at night, so it's like, oh, if you're going to be in the day, it's not there. And then we're on a blacktop track, so it's just, you feel the heat is coming right back. It's very interesting, I don't even know if he recognizes this, because he's lost all the people. He's found it very well.
Muscle.
Okay.
By dragging this down here, we've now extended this by another 5 days. Just so you know, we just extended another 5 days. 5.
Okay. So,
Ready to go back on?
Yes.
I believe we are.
You need a roll call to come back on?
Okay, so the County Officers Electoral Board is hereby reconvened from the previous 15-minute recess. I mean,
Should I ask chorus of laughter?
yes,
Of course.
please. Yep, let's take a roll to reconvene. Do I? Yes, please.
Oh, Tim Brophy,
Here.
Lauren Staley Ferry, here, and myself, Karen Stucco. Here.
Okay, all present.
So, the board should know it took a little longer than anticipated. There were some IT issues with regards to the filing of the motion. We've been trying to figure out a briefing schedule that accommodates both the motion that was filed and also makes good use of the time. We're looking at Monday at 10 a.m., if that's convenient for the court, with the acknowledgement that if it goes overly long, we may need to go into a second day of hearing on it, depending how long witness examinations go.
Can I ask, what is it?
The hearing, sorry, it being the hearing on the ultimate objection.
Oh, so we're going to hear the ultimate objection at 10 o'clock on Monday.
Yes, unless there's some sort of ruling on the motion that indicates that the board is improperly constituted, and in which case we'll come back and we'll have a replacement member appointed for the clerk if the court overrules the board's motion.
If in order, Madam Chairperson, move we adjourn till Monday at 10 o'clock.
The only other issue, as far as for filing of briefs for the motion, when do you want the briefs filed by?
For the motion, the
His
objection.
objection.
Mr. Ivick, how long would you like to file a written response to the objection?
File it as soon as Friday or.
By Friday, all right?
Business Friday.
So is the court okay with receiving the written response to the objection?
Let me understand what's going on. You filed an
Can you
emergency,
take your mask off? I'm
sorry, you filed an emergency motion to do what?
For judicial review of your decision not to
Okay.
recuse.
And you filed an objection to that?
No.
No, the objection is the underlying
Oh, the
objection
underlying
in this
case. All right, okay, sorry.
So, if the board's okay with granting Mr. Ivick until close of business Friday to file his written response to the underlying objection to the petitions. Then,
Responses or brief?
well, brief memorandum response. how
We both have to have an opportunity to file something.
And I'm anticipating that, Mr. Piles.
Why don't we just file both of our, we know what the issue is, we just file our briefs both on Friday.
If you'd like to both file your briefs contemporaneously, that's fine too. So both parties to file their briefs in support of and in opposition to the objection by close of business Friday. And I think if there, I don't think anyone wants time to reply. Obviously, it's going to be cross motion here. So.
Right, and then service of the briefs on the board to you or to?
You can serve them on me and the board, please, and the chairperson.
Could you ask that they file briefs by 4 o'clock at least, so that we can get them Friday, so we can read them before Monday morning? That would be good.
4 o'clock, all right with you gentlemen? So if you can, the deadline will be 4 o'clock to file the briefs in support and opposition. And we'll set it Monday, 10 o'clock for hearing on the objection. If we receive an order from the court that would otherwise impact that schedule, we'll handle it on Monday. All right, so
Motion on the floor to adjourn.
there's a
till
motion on
Monday
the floor
at
to
10
adjourn.
Second.
Sorry, adjourn the hearing, then we'll have public comment, then we'll adjourn.
I'm sorry. Yep.
All in favor, say aye.
Aye.
Opposed, say nay. Motion carries. Is there anybody in the public that would like to comment today? Any public comment today? Last chance.
Last call.
Last call. Okay. Seeing no public comments, I need a motion to recess until Monday at 10 a.m.
So moved.
Second. All in favor say aye, opposed say nay.
Aye.